Hey there, welcome back to Reddy and Neumann. We're back again for another week of live updates on immigration every Tuesday at 5 o'clock. Coming to you live from Houston, Texas, where we're one of the biggest immigration law firms in Houston. And today I have with me Rebecca Chen, who is a senior partner here at Reddy and Neumann, and I'm Emily Neumann, managing partner here. Today we want to give you some updates on the latest of immigration and of course answer your questions like we always do. So one of the recent updates is the Meng amendment, which we've talked about. You've probably heard about it before. Where does it stand now? What's going on with it? What's included with it? Is it a good thing or a bad thing? We'll also give you updates on all of the planned regulations that are kind of in the pipeline that would affect employment-based immigration. The regulatory agenda came out recently for the spring, and so we'll give you the updates on what we think is going to be proposed and what the timelines are going to be for that. We also want to talk about a common issue that we see happening is I-94s that are expiring. This is usually due to some sort of travel, and people don't print their I-94 online after they travel and assume the date is something other than what it actually is and end up overstaying that I-94. What can you do in that situation to correct it? How serious is it? And lastly, a very common question we're getting right now is for people who are interfiling to transfer their EB3 485 back into the EB2 category. You know, what is this provision USCIS is saying that the 180-day clock resets, and how is that working? Do we have any results from that? We'll give you the updates there, and of course we'll answer your questions. So going back to the Meng amendment, you may have heard of this last year. Meng is a representative in the House who had tried to add an amendment to one of the previous bills in order to deal with the wasted employment-based green cards, actually family-based as well. It's been tried a number of times. It has not gone through. So now this latest time is part of the Department of Homeland Security spending bill. So the House Appropriations Committee had their markups where they were adding amendments to the House version of the bill. And this amendment was added to it yesterday, and it did pass through the committee. Where does it stand now? It's still very early on in the process. So this is just the House side of the DHS spending bill. From here, it's only passed through the committee. It still has to go through the full House. The full House, anybody might be able to add an amendment to it. They might be able to take away this amendment. They might change it into something else. So we've got a long way to go on the House side, but even then we have the Senate side. They're going to come up with their own provisions. They may leave it out completely. They may put it in a different way that might be beneficial or might not be beneficial, or they might do the same thing as the House, but generally they don't do the same thing as the House. So we're going to end up with two competing bills. House and Senate are eventually, by October 1st, going to have to get together and come up with a final version of the bill. The Meng amendment could be completely gone at that point. It could look completely different from what it looks like right now. So don't get your hopes up that it's going to happen. And even if it does happen, it might turn out to be something that we didn't expect or didn't want. But we should have a final bill on that has to be signed by October 1st by the president. Otherwise, we go into this whole continuing resolution process in order to keep funding the government. So what is actually in the amendment? Because there's been different things at different times. So this version of it would basically recapture green cards that went to waste between fiscal year 1992 and fiscal year 2022. It also would stop the spillover from family-based into employment-based from happening going forward. So this would take effect October 1st, 2022, which is fiscal year 2023. So we would no longer get that family-based spillover. And on top of it, when we're calculating how many green cards actually get recaptured, they're taking away the family-based spillover that we already have. So they're saying that you can't recapture those because you've already gotten them when, we think you shouldn't have, I guess, is the thought process behind that. So the number of recapture, we don't really know exactly how many it is. Estimates over the years have been anywhere from maybe 200,000 to 400,000 green cards. So those might become available. And then if we don't use all of those up by the end of fiscal year 2023, they will roll over to the next year and keep rolling over. So after this, we won't be wasting them anymore. So that's a good sign. And all those recaptured green cards will be available into each category, EB1 through EB5, in kind of the same proportion we already get them, but the per country limit does not apply. So this would definitely be a benefit to the backlog community, Indian and Chinese immigrants in the EB2, EB3 category, but it's got a long way to go, so don't get your hopes up on that yet. Regulations that we've got coming up. So we can expect a proposal. So the regulatory process, we get a proposed rule first, then it's typically the notice and comment period. That's usually about 60 days. We submit our comments. Everybody in the public submits their comments for and against. Then the government takes all those comments, decides whether they need to change the regulation, whether they're going to just not do it in the first place, or whether they're going to go ahead with it as it was, and then it goes to a final rule, and then that final rule will actually take effect usually within 45 to 60 days after it's published. So this is just letting us know what might be proposed within the next year or so. So we're looking at a proposal in May 2023, a year from now, that will update the adjustment of status processing to make it more efficient, possibly, reduce processing times, try to improve the inventory data, and reduce possible retrogression, try to more efficiently use the available visa numbers. But again, that won't be proposed until a year from now. So it could be even a year beyond that before we even see those regulations come into play if they decide to go with it. So that's number one. Number two, coming this fall, should actually be a final rule. We've already had the proposal. No, I take that back. Proposal coming this fall, September, for a fee increase. So we should have known that that was coming since we've been trying to increase, not us, but the government's been trying to increase US CIS fees for some time. The last time around it didn't work out because of the way Trump was trying to do it. Now I would expect it's going to go through, so all of our filing fees are likely to go up. Another expected proposal for May 2023. Again, that's when it's going to be proposed, which means it will take time for it to actually be finalized, and it could end up completely different than what they say, or not at all. But they're wanting to modernize the H-1B and oversight and provide flexibility for F-1. So again, they're looking at revising the definition of employer-employee relationship. They mentioned providing flexibility for startup entrepreneurs, which is new. That's a good sign. Maybe they're meaning that they're going to allow people who started a company to actually use that company to file the H-1B for themselves, because currently that's generally not allowed, except in limited circumstances. They're looking at modernizing or changing how they do site visits. This will typically be for H-1B dependent companies. They want to address the cap gap issues that happen with people that are trying to transition from F1 to H1, possibly bolster the registration process for the lottery to reduce fraud and misuse of that system. Obviously this year we saw, 475,000 registrations. Clearly those are not all for, one registration for one person, so there's got to be some misuse going on there. So hopefully we'll see some beneficial changes there, which would improve people's chances of getting selected. And then a big one that you probably haven't heard about is for certain companies that have 50% of their workforce on H-1B or L and they're H-1B dependent, they actually, and they have more than 50 employees, right now they have to pay an extra $4,000 filing fee for every H-1B new petition they file, or a $4,500 filing fee extra for every new L petition they file. Now the government, this is expected to be proposed in October of this year, is going to expand that to all petition filings. So that means it includes extensions. So not just transfers or cap petitions, but also every single extension that company files is going to cost an extra $4,000 or $4,500. That's probably meant to generate a lot of fees for the government. And actually, that's how the statute was written, to include extensions. It's very clear in it, and it's kind of interesting that USCIS has not been requiring that all along. So that's likely to come up pretty soon. Prevailing wage calculations, those have been all over the board. If you recall, back in October 2020, the Trump administration tried to completely change how prevailing wages were calculated. That lasted for maybe a month, and then that was blocked by a court. We had to go back and get new prevailing wages, do new LCAs under the old prevailing wages. So since then, the Biden administration has kind of kicked the can down the road, and now it looks like October 2022 is when they're going to do a new proposal starting from scratch with how they want to now recalculate prevailing wages. And lastly, the State Department, we're expecting a final rule on their increased fees for visa applications, which will hopefully provide more revenue for the State Department to get us more visa interview appointments and get more applications processed, because we're still having problems with getting things taken care of at the consulates. So that's the regulation side. Now, one of the common topics we wanted to talk about is what happens when you have an I-94 that's expired, but your I-797 is valid. So Rebecca, kind of what's a common scenario where that happens?
Yeah, so we see that a lot when people travel, come back into the US, and they come in with their I-797 approval notice that's valid for 3 years, potentially, if they just recently got their H-1B approved. And then they enter the US, but they're not aware maybe that when they come into the US, CBP always issues a new I-94. Every time you enter the US as a non-immigrant, CBP issues you an I-94, and it's not the best system because you're not always aware even that you got a new I-94. You think the I-94 is the one attached to your I-797 approval notice, but actually that CBP generated I-94 is electronic, it's online. You have to go onto CBP's website, enter your passport details, and then it generates your I-94 record. And on that record, if that is the most recent entry, that I-94, that online record, is actually what controls your status from the time you entered the US most recently. And so if CBP has put a shorter duration on that online I-94 than what is on your I-797 approval notice, it could lead to issues. It could lead to you actually overstaying your I-94 inadvertently. And so why would CBP put a shorter duration on your online I-94 than what's on your I-797 approval notice? The most common scenario where that happens is where your passport expires before the I-797 approval notice expires. So if your passport validity period is shorter than the I-797 validity period, CBP pretty routinely matches the end date on your I-94 to the end date on your passport. And sometimes they will tell you that they're doing that. A lot of times they don't. And so a lot of times people aren't aware that their status actually expires maybe in 1 year instead of the 2.5 years that they thought they had left on their I-797. So it really is a situation that you can inadvertently overstay your I-94. So it is it can be a pretty serious situation if you end up overstaying for more than 6 months past that electronic I-94's end date. So the first thing to kind of keep in mind is to always remember to check your I-94 online after each reentry into the US and be aware of that end date. But if you do find yourself in a situation where that online I-94 has already expired, what can you do in that situation to try to fix your status? So there are a couple of methods. One method is through travel again. Just take another trip outside the US. If you have a valid visa stamp, that can be done pretty easily if you just renew your passport. Of course, if your I-94 was cut short because of an expiring passport, make sure you're coming back with a renewed passport so that you don't end up in the same situation. But if you travel, come back with a renewed passport, your I-797 approval notice, you should be issued the full duration on the I-94 when you re-enter the US by CBP. Even if you don't have a valid visa stamp in your passport anymore, you may be able to do automatic revalidation, going to Canada or Mexico for a period of 30 days or less and coming back in with the expired visa, the I-797 approval notice with the I-94 attachment that is still valid, and that is another way where CBP will give you an I-94 record that is matching your I-797 end date, also with the renewed passport. If travel is not a possibility though, or if you prefer not to travel, another option is to file an I-539 extension of status if it's you know, an H4 or L2, or if you are in H1B or L1 status, filing an I-129 petition. That may be a little more difficult because, of course, filing another H or L extension will require your company's cooperation, so you'll need to discuss with them. They may prefer that you just go outside the country and come back in, because then they don't need to pay any fees to file another application, but that would be another option, filing another application. If you're filing it at a time where the I-94 has already expired, you may need to include a nunc-pro-tunc argument in that application. Basically, the nunc-pro-tunc argument requests USCIS to excuse the late filing, basically the gap in your status, due to extraordinary circumstances. And you'll need to include the argument. There's kind of a four-pronged argument for the nunc-pro-tunc argument, explaining the extraordinary circumstances, that you didn't realize your I-94 had expired already, and detail those issues. But as long as you explain it and invoke the nunc-pro-tunc argument, for the most part, USCIS is pretty flexible on granting that that excusal of the late filing and still extending your status if the gap isn't too long. I would say if it's less than 4 months or so, that's probably there's a good chance that they will still extend it. And then some people might also contact CBP Deferred Inspection to see if they will update the I-94. I would say if the I-94 shortened duration is due to a CBP error, that may be something that can be fixed by contacting CBP Deferred Inspection, and a lot of deferred inspection sites now will actually take a request through email. You don't have to go in person. However, CBP has stated that if the shortened I-94 is not due to error, and they don't consider cutting it off based on passport expiration in error, they won't fix it at deferred inspection. So if you are in that situation, it's probably best to consult with an attorney to make sure you're aware of what your options are and go forward from there.
Yeah, and travel, definitely be careful if your I-94 is expired more than 180 days ago, because that can trigger a bar to you coming back. So that may limit your options there. But definitely talk to an attorney. And most importantly, every time you come back in, please print your I-94 and check that date. Make sure it matches what's on your approval notice. If it's shorter, keep track of that date and make sure you take action before you cross that date. It's much easier to fix before it expires than after it expires. All right. Very common question that we're getting right now with all of these interfilings. We have people who did the downgrade back in October 2020. 485 is taking forever. EB3 is no longer current. Now they have the I-140 and EB2 from the same company, and USCIS keeps telling everyone, please request to transfer your underlying basis. We have so many green cards in EB2. Please upgrade to EB2. So everyone's doing this interfiling process, but what happens when after you interfile, you want to change jobs? You know, we have the AC21 rule that allows that, but you know, is it limited? Is there any restriction on that if you've interfiled recently?
So according to USCIS's website, there is a restriction. They've stated that if you have requested to transfer the underlying basis of your pending I-485 application to a different immigrant petition, then that basically restarts the 180-day AC21 clock that you would usually need to wait out in order to be eligible to change employers safely and keep the I-485 application pending. So that is on USCIS's guidance website. That's what they've stated. Whether that really is needed to wait another 180 days from the time you file the J supplement requesting the interfile, I would say that is more arguable. There isn't anything in the AC21 regulation itself, from what we have seen, that requires that resetting of the clock based on an interfile request. It just requires that job portability just requires that the I-485 application has been pending for at least 180 days, which by the time, for people interfiling, you know, this year, most of them are have been pending for well over 180 days if you filed in October 2020 or around then. So if you are in a situation where it's been less than 180 days since you've interfiled, you have a new job offer that you would really like to take, we do know some people have just gone with the new position. In that situation, if you are going to try that, and be prepared to make the argument if it comes up from USCIS about why you didn't wait 180 days, in that situation, we would probably, since it is kind of arguable whether you need to wait those 180 days, we would probably recommend not filing the J supplement that alerts USCIS to the new employer. That's another function of the J supplement, is to request portability to a new company under AC 21. But we know it's not absolutely required that that J supplement to the new employer be filed right away when you move to the new company. A lot of people have been moving to the new company and just being prepared to submit that J supplement if USCIS requests it. So that may be one way to kind of avoid having to make the argument that you still qualify for AC 21, is not submitting the J supplement when you move to that new employer. And then, just hoping that USCIS adjudicates your I-485 in time and that you get the green card by September 30th, potentially, without having to make that argument with USCIS.
So do you think if someone has done the interfile and changed jobs within 180 days and USCIS catches on, do you think that, worst case scenario, are they going to deny the whole 485?
We don't think so. We haven't really seen kind of the outcome of this particular scenario, but it seems like even if USCIS was aware that there was a job change before 180 days from the interfile request, and they decided not to apply AC 21 to that situation, the worst that should happen is that the I-485 would remain pending in the EB3 category. The denial of an AC 21 request, of an interfile request, doesn't nullify the I-485 itself. So it seems like it would just invalidate maybe the interfile request, so that your application can still remain pending in the EB3 category, and it could be approved eventually when your priority date becomes current in EB3.
All right, well, I guess we can get to some questions now. Hemchen from YouTube has an interesting situation. My attorney sent the recruitment details to the old DOL address. Is this something that they can deny the perm application for? So I'm assuming maybe this was in response to an audit, and it is possible. If they caught it early enough to where the deadline has not passed, they should definitely refile the audit response to the correct address before the deadline. If it's already past the deadline, they can try sending it to the correct address and include an explanation of that they did submit it previously and proof of the postage and all of that. But nowadays, the audits are actually able to be uploaded into the perm system, so it's unclear why it needed to be mailed in, unless there was some problem with the perm account. But yeah, it is a pretty serious problem, unfortunately. It's something that if the perm application was denied, perhaps they would be successful on an appeal by showing that they realized the mistake and they did actually send it and it went to the wrong address or something like that. But that appeal process is very long, so it may be something that they want to start the perm process over again while you're waiting for the result of this case.
Barath from YouTube is asking about a situation where it sounds like he interfiled and his I-485 was successfully transferred from Texas or Nebraska to the National Benefit Center, but around the same time he also filed a new I-485 in the EB2 category, and is asking if that is a problem. Would they conflict with each other? I don't think so. It seems like it wouldn't really be necessary to refile in that situation if you've already interfiled, because now you have two I-485 applications, both in the EB2 category. But I don't think the fact that you've refiled would necessarily conflict with the interfile. They may just combine the files there at the National Benefit Center. but it shouldn't really delay anything.
Krishna said that my blog gave a data point for an EB2 direct approval in 2.5 months, and he wants to know if the Q2 data has been released by USCIS and what can we expect for the remaining quarters. So no, they still have not released the data for the second quarter of the fiscal year, which would be for January, February, and March. It should be coming anytime now. We usually get that in June. And yeah, we are seeing, if you go to immigrationgirl.com, the top post there shows you the cases that our one of our attorneys in our office is seeing in real time. You'll see the very first one, the most recent approval, literally took 77 days, and the next one took 600 days, and then another one was 70 days, and another one was 500 days. The 500, 600-day ones are Texas Service Center downgrades. The 77-day ones are straight filing. EB2 already, the I-140 is already approved, and they went directly to the National Benefit Center. So obviously a huge difference in how they're processing these applications. But we don't have the data, and USCIS needs to keep picking up the pace if we're going to make sure that we don't waste green cards this year.
Senthil from YouTube received his I-485 based EAD AP card, and he and his family are still in H status right now. He wants to know if he starts using the EAD, will his family lose their H4 status? So yes, potentially. So when you do move from using the H-1B status to using the EAD card is not really attached to any non-immigrant status. It is based on your I-485 application being pending. So when you start using that GC-based EAD, you're kind of no longer in H-1B status. Your status in the U.S. is now based on the pending I-485, which means that for your family members who are in H4, they should probably consider that their H4 status is no longer valid. They are still also in a period of authorized stay based on their pending I-485s. But for example, if you have a spouse who is using an H4 EAD and she has not yet received the EAD from the pending I-485 application, that may be something to consider before you use the EAD, because doing so may potentially invalidate the H4 EAD, which could leave your spouse without work authorization until she receives the EAD based on the I-485.
Binyam says, how long after the transfer to the National Benefit Center or field office are you seeing approvals? Mine was transferred in mid-March and still no update after that. And what's the criteria for transfer to the field office? So we did add that data point on immigrationgirl.com, so you can look through all of our recent approvals for one of our attorneys. And we, for those cases that were transferred to the National Benefit Center, we've listed the date it was transferred along with the date of approval and the number of days it took to get to that point. Off the top of my head, I'd say average is anywhere from 45 days to 120 days, but you can check the actual data on immigrationgirl.com. In terms of, having it transferred mid-March and nothing's happening, very common. You're definitely not alone there. Is there a criteria for transferring to the field office? I think the #1 criteria is cases that they intend to interview. Those would be situations where maybe they have an immigration history that they need to address. Maybe they have a criminal background that has to be addressed. Beyond that, maybe there's something with the employer that they have some kind of immigration background. Beyond that, it just seems to be whatever field office maybe has fewer cases to deal with and has officers available. They're sending applications there. I don't know if there's any rhyme or reason to it.
Santosh from YouTube has an I-140 approved in the EB1C category and received the EAD also. He says his L1A has been pending for 17 months and wants to know if now that he has the EAD, can the pending L1 application be withdrawn? So that depends a bit on when the I-485 application was filed for your green card process. One requirement of the I-485 is that you have to have been in valid non-immigrant status at the time the I-485 application was filed. So if your L1 extension was pending at the time you filed your I-485 application, you do need that L1 to eventually be approved. It's fine to file the I-485 while the L1 extension is pending, as long as it is eventually approved. if you withdraw or your company withdraws the L1 before it's approved, or if the L1 is denied for some reason, that could have an impact on your I-485 eventually being approved, because it could lead to more than 6 months of out of status time, which would result in the I-485 being denied. So I would definitely check carefully kind of the timing of when your I-485 was filed versus when your L1 extension was pending, and consult with your company's attorney before withdrawing the L1 and using the EAD.
Raj says, I had a cap exempt H-1B for 2 years and a cap subject H-1B for 3 years. Now to recapture time, is it 1 year or the cap exempt time used? So even though you were cap exempt, that does count towards the 6-year limit. So you've only got 1 year left at this point when you're calculating how much time you've spent in H-1B status and how much time you have to recapture.
JCP Reddy is asking if USCIS seems to have enough inventory in the EB2 category, because back in May they did kind of release a statement that they had about 16,000 that they had interfiled, or interfile requests that they had received. Based on the most recent statements from USCIS, we expect that USCIS probably is not going to move forward EB2 dates any further this fiscal year, basically in the next few months. One indication of that is the filing dates did recently move forward in Chart B of the visa bulletin, but USCIS stated that for July they would not accept the filing dates chart. They're going only by the final action dates chart for July, which indicates to us that they feel that they have enough inventory to kind of meet their target for now. So we're not expecting at this time that the EB2 dates would be moved forward before October potentially.
Let's see here. Venkata said, if the child's age is locked in EB3, and then if I interfile, will USCIS recalculate the child's age again? Yes, they do. So you definitely need to look at that before you interfile, because it's possible that the child's age may be locked with respect to EB3, but not locked with respect to EB2, or their age may not be under 21 when it comes to calculating under EB2. So the I-140 that is supporting the 485, that's the one that they will use to calculate the CESPA age. So let's say your EB3 I-140 took a year to process, not great at the time, but good for your child because they subtract a year from their age. But if your EB2 I-140 only took 2 days to process, you can only subtract 2 days from their age. So it's very important to recalculate that. You look at what is their real age on the date, the first day of the month where their EB2 date became current, subtract the number of days the EB2 I-140 was pending, and if that puts them under 21, and the final action date, of course, is what I'm talking about here, and your EB2 I-140 is approved, yes, their age would be locked in that situation, and you have to submit the interfile within 1 year of the date that EB2 final action date became current. That's the 1 year rule that they recently announced, so that you are seeking to acquire permanent resident status within 1 year. That's what all of that combined locks in the age.
Senthil has a question about birth certificate documents for the I-485. For his wife's application, they submitted secondary evidence, which I assume is documents like the school records or anything else like that from when she was young, in addition to a parent's affidavit for proof of birth with the I-485 application. And he wants to know whether there's a possibility of getting a request for evidence in that situation. There is a possibility that you may still get an RFE, even having submitted the secondary evidence in a parent's affidavit. We usually, if the birth certificate is not available, we try to get the non-availability certificate from the government in India, like from the municipal or local government authority in India. They can provide a statement or certificate basically stating that there wasn't a record of this person's birth at the time that they were born, which is called a non-availability certificate. USCIS does sometimes require that as part of their birth certificate evidence. So if you have not already started to obtain that non-availability certificate, we would recommend going ahead and starting the process, because it can sometimes take a while to get that certificate from the government. Go ahead and start that process even before you get an RFE, so that you have it ready if the RFE comes in. In addition, for the affidavits of birth, we usually recommend that the affidavits be issued by someone who is not the parent of the child. It can be from almost anyone else who is older than the applicant, old enough to, conceivably remember the applicant's birth. So an aunt or an uncle, family friend, anyone else. So if you can prepare 2 affidavits also from people like that, in addition to the non-availability certificate, those should be sufficient if you do get an RFE.
Sriram says EB2 straight was filed directly with NBC December 2021. It's still sitting there for more than 6 months. Any idea what is the trend? When can we expect the approval? As far as trends, it's all over the board. I remember helping my kids with their math homework, and they had to make those scatter plot graphs. I mean, that's what it looks like. It's just scattered all over the place. You can see the data on immigrationgirl.com. We're getting cases filed in January, February, March 2022 approved. We're getting October 2020 approved. We're getting October 2021 approved. And that's a huge variance, and there's just nothing we can do about it. They're not clearly processing first in, first out. They're just getting whatever they can put their hands on and approving it. When can you expect the approval? According to USCIS, by September 30th. They're supposedly working on getting every case that was filed by June 2022, by early June 2022, I believe is what they said, when it was a straight I-140, based on an approved I-140, final action date current. They're trying to get all of those approved by September 30th.
Subhash is in H-1B status currently and is asking, so he has an opportunity to become a partner or investor in a store, and is asking if that is permissible while he is in H-1B status. So you do have to be pretty careful about investment and partnership activities when you are an H-1B employee. Any investment activity that makes it look like you are going to be actively involved in operating or directing the business can look like employment for that business and it has not sponsored your H-1B. So when you're in H-1B status, you're only authorized to be employed by the company that sponsored your H-1B visa application. So if, for example, it's a pretty small business where you are, definitely if you are the sole investor, that is going to look problematic. But even if you are one of a few investors, that can also look problematic, because for small businesses with just a couple or a few shareholders, usually those shareholders are going to be doing everything to kind of get the company or business off the ground. So we usually recommend that H-1B visa holders avoid that type of investment situation. The type of investments that H-1B visa holders can safely engage in are passive investment. For example, trading stocks in the stock market, being a shareholder of a large corporation where it's, not questioned that you have any involvement in the operation or running of the company. So only sort of passive investment activities where you're not in danger of looking like you are involved in operating the business.
Manish has an EB3, EAD, and AP, and he's current in EB2 under the June visa bulletin. Just did the interfiling and is planning to travel from July to August and wants to know if that would be a problem. So the interfile doesn't really impact anything. It just act like you have a pending 485 all along. So the interfile is just underneath, it's transferring you from one category to the other, but the 485 remains pending the entire time. So that EAD that you had based on that 485 and that AP that's based on that 485 remain valid as long as your 485 remains pending. So assuming your EB3 I-140 is approved, your EB2 I-140 is approved, you don't have any criminal background, any grounds of inadmissibility that have come up after you filed the 485, it's generally safe for you to travel. You might end up getting your green card approved while you're abroad. That generally is not a problem. You can either have the card mailed to you by someone here, or you can use your AP to at least board the flight, and then once you land, they will be able to verify that you're now a green card holder at CBP.
CAIO is in L1 status currently, and it expires in August. They're not eligible to extend it anymore beyond August, and they have a pending I-45 application that's been pending with the I-765 since for the past 10 months, and wants to know if there's any way to expedite the EAD. So this has been a huge problem for a while, the delay in the EAD. EADs being issued, resulting in many people losing work authorization and having gaps in work authorization. You can try requesting an expedite, although if you are not a member of the healthcare professions, the healthcare professions are really the only group that USCIS has officially identified as being eligible to request an expedite, and they have been expediting those EADs pretty quickly if you put in that request. If you are not a member of the healthcare professions, it's going to be a lot more challenging getting USCIS to request to issue an expedited EAD. It's basically a process. It's outlined on the USCIS website, but you basically have to call their customer service line, give the reason as, for example, an urgent business need that the company can support through some kind of documentation, and then they may instruct you to send in those documents. But for the most part, it is very difficult to get USCIS to issue an expedited EAD in those situations. There are some litigation options that have been somewhat successful. So if you are interested in one of those, we recommend contacting Stephen Brown in our office to see if you might be eligible for relief through litigation.
Bushana had filed the downgrade in August of 2021, and that I-140 is still pending. Ended up filing a second 485 and EB2 in April 2022, and that date became current, and wants to know, is there any connection between the downgrade and the refile? Technically, no, there should not be any connection because it's based on a completely separate I-140. Even though they're the same labor certification, those I-140s stand alone, assuming that it was not done as an amendment or anything like that. Now, in reality, we were seeing many times the refile would start out at the National Benefit Center and then get transferred to the service center where the I-140 was still pending from the EB3 case. And it would only get transferred back after that EB3 I-140 got approved. So even though they're not dependent on each other at all, USCIS does seem to, maybe there's kind of some delays or something happening there. So you may want to consider at this point withdrawing that I-140 that's still pending in EB3, since you technically don't need it for anything. Or if you really want to get that, avoid having them be interactive with each other, upgrade it to premium processing would be the other option to get that approved as quickly as possible.
Smoothie received an RFE on his EB3 I-140 for ability to pay. So that is something that could occur with the EB3 downgrades because the priority date is likely going to be several years back. USCIS, they haven't always, but they can request proof that the I-140 petitioner has maintained the ability to pay the proffered wage from the priority date, which may be 10 years ago now, until the present. So that would mostly be in the form of if you've been working for the I-140 petitioner continuously since the priority date, that is usually the strongest proof of the company's ability to pay. If you have your W-2s and pay stubs and they are at or above the proffered wage, that alone is kind of proof enough of the company's financial ability to pay for each of those years. If there are any years where your pay was below the proffered wage listed on the I-140 petition, then the next document USCIS will look at is the company's tax returns for that year, or their audited financial statement, or if the company has over 100 employees in the US, a letter from the CFO could work to attest to the company's financial position for that year. So as long as the difference between your actual wage and the proffered wage is, it can be shown on the company's financials, either in their net income or net assets, that is also enough to overcome an ability to pay RFE.
Vishnu has an approved EB3 I-140 with his current employer and an approved EB2 I-140 with a previous employer. He already filed the 485 based on his current employer's EB3 and wants to know if he can interfile to EB2 based on the old employer's I-140. Technically, yes, as long as the old employer is still in existence, they still are offering you that same job. They need to be offering you that job at the time you receive the green card, and it needs to be under the same terms and conditions that were on that old labor certification. That means same job title, same salary, same work location, same job duties. At the same time, you need to intend to take that job offer when you get your green card. You and the old employer will be signing under penalty of perjury on that Supplement J, confirming that the employer intends to offer you that job and you intend to take that job when you get your green card. So if everybody is willing to do that and that job offer is legitimate and still there, yes, you could do that.
Prashanthi has a pending I-485. She filed as the derivative of her husband's I-485, and he is the principal applicant, and she is asking if she can safely switch jobs before their I-485s have been pending for 6 months, or does she need to wait the 180 days? So the 180-day rule for changing jobs is only applicable to the principal applicant because the I-485 application for him is based on the I-140 petition, which is based on a job offer, which needs to remain valid for at least 180 days before that principal applicant can move over to a new employer and a new job offer and keep the green card process ongoing. That does not apply to you personally. If you're a derivative of the principal applicant, then you can change employers well before the 180 days. It won't be an issue for you at all. Your new employer does not need to submit a J supplement on your behalf.
Raghu says, my priority date is current and my I-140 is still pending. AOS is filed. What's the best course of action? Is it worth it to go for premium processing? So yeah, at this stage, your 485 cannot be approved until your I-140 gets approved. There are very few things that you have control over at this stage of the process. Getting that I-140 approved by upgrading to premium processing, assuming your employer is willing to do that, is one of the few things that you can do to try to get your green card faster. So I absolutely think it's worth it to upgrade that to premium processing, because otherwise that 485 is just going to sit there until the I-140 gets approved in regular.
Harsh is asking if a new visa stamping is needed after an H-1B amendment has been filed, if the prior H-1B visa is still valid. So no, you don't need to get a new visa stamp just for the H-1B amendment. Actually, even if you were to transfer employers to a completely different company, if your existing H-1B visa in your passport has not yet expired, you can still use that stamp, that visa stamp, to travel internationally. So that visa is not company specific. As long as it is unexpired, you can use it to apply for entry into the US. You just always need to make sure that the I-797 approval notice that you're presenting is for your current employer, so that the I-94 that CBP gives you, like we were discussing earlier, matches the end date, the validity period on your current employer's I-797 approval notice.
Prashanthi says, I'm on H-1B. My 485 was filed through my spouse's employer last month. Can I switch the job now? Does the 6-month clause apply to me or just for my spouse? It only applies to your spouse, who's the main applicant of that 485. So you absolutely can change jobs at this time by doing an H-1B transfer, or you can wait until you get the EAD card and do it that way as well.
Chandu is asking if he used his advanced parole to travel, can he continue on H-1B, or does he need to switch to the EAD? So there is a provision, there's a memo basically that states that if you used your advanced parole to enter the US, one way of thinking about it is that, when you use the advanced parole to enter the US, you're no longer in H-1B status, and that you should basically be considered an AOS applicant and need to use your EAD to work. However, there is a memo that has stated that if you enter using the advanced parole and your H-1B validity period has not yet expired at that point, the H-1B petitioner can file an extension of that H-1B status without you having to depart the country and get a visa stamp, for example. So if your intention is to continue on H-1B, if at the time you re-entered in advance using the advanced parole, the H-1B was not expired, you could probably just continue to work according to the terms of the approved I-129 petition, and your employer would be able to extend that H-1B later, so you don't necessarily need to move over onto the EAD.
Kellogg's fan says, I already got my GC in my hand, and then after that I received a denial of my AP application that was submitted concurrently with it. Should I respond or ignore it since I have my GC? Well, that's definitely the best kind of denial to get, so you can absolutely ignore it. You don't need it anymore, and it's denied because you don't need that benefit. You have a green card, so don't take any action with that.
Paula is asking, when will premium processing for EB1C be expanded? So we haven't received any updates yet from USCIS on the premium processing expansion for EB1C or NIW. As it stands now, as of June 1st, EB1C I-140s could be upgraded to premium processing if they have been filed and pending since before January 2021. And starting July 1st, NIW I-140s can also be upgraded to premium processing if they've been pending since, I believe, sometime in 2021 also. So it is pretty limited, the premium processing options for EB1C and NIW right now. The hope is that USCIS will expand premium processing to cover more applications that are pending and eventually enable new applications in these categories to be filed with a premium processing request initially. But as of now, there are no announcements yet.
Srikant says the primary 485 application was approved, but the dependent's 485 is still pending in the Texas Service Center. What are my options to expedite the dependent application? Very limited. Usually USCIS does not expedite adjustment of status applications at all, even though the primary applicant received the approval. And we're seeing more and more where they're splitting up the family members and approving some but not the others. So it is, while it's not common, it's definitely not unusual. It does happen. I think probably your only real option to expedite would be to litigate it, file a lawsuit against the government for the delay in the adjudication of the dependent's 485. That would depend on how long that 485 has been pending. If it's something you're interested in, you can contact Stephen Brown at our office.
Amarash is asking, could a company file a transfer for him while he's outside the U.S., and then can he use a prior employer's visa to travel into the U.S.? So yes, so that's along the lines of what we were talking about before with the visa in your passport not being company specific. So if you do get an I-129 petition filed and approved by a new company while you're outside the U.S., then you can use that new approval notice and your existing H-1B visa, if it is not expired, to travel into the U.S. And be admitted without having to go through the consulate.
Prince says, can you share your learnings from the New York City conference, please? Anything interesting? Yeah, so I was at the American Immigration Lawyers Association annual conference recently in New York City. And, you know, usually the biggest takeaways we get from that are during the government open forums, where the different agencies involved with immigration actually come to the conference and sit on a panel and answer questions about what's going on with the agency, giving us latest updates and kind of what to expect. Now, this is not a back and forth question and answer session, so it's not like any of our attorneys get a chance to ask questions of the different agencies. Unfortunately, the way they do it now, the ALA committee comes up with the questions in advance, gives it to the agency approves which questions it's going to answer, and they only answer those questions. So our information is a bit limited by that, but coming from the State Department, the biggest takeaway they gave is they're actively exploring, those were their words, the idea of bringing back visa renewals in the US. So way back 20 years ago, if you already had your visa and you came into the US and then you filed your extension and now you wanted to travel again, your visa stamp has expired, you could actually mail in your passport to Washington, D.C., and they would stamp it there with your extended H-1B or whatever visa it was and mail it back to you, and then you could travel. They stopped doing that, claiming that they didn't have the ability to do biometrics. Of course, now they do biometrics for everything, so they should be able to bring that back. And this is the first time the agency actually said they're considering it. The word they said was actively exploring. Now, just because they're exploring it doesn't mean that's actually going to happen. I don't know. It's a very long time that we might see these things happen, and obviously things change with administrations. But it was a good, hopeful point that maybe we'll get back to that someday. Beyond that, this did not come directly from the State Department's agency forum, but one of the panelists that is not a government representative, kind of was explaining some of the issues that the consulates are having. Why is it we're not getting appointments? Why is everything still backlogged after all this time with COVID? The State Department lost many consular officers. They either left the profession or, are no longer doing that job because the consulates were shut down. They didn't have any work to do. And so they're having to basically rebuild their consular officer staff. And, the unfortunate thing is they said it might take 10 years to get back to where they were pre-COVID in terms of their ability to process that number of visa applications. So definitely not good news there. Hopefully with these increased visa application fees, that will help them hire more. Speaking of hiring, USCIS told us that they have 4,000 job openings. They have a 20% vacancy rate. So basically they lost 20% of their staff during COVID and are still trying to bring them back and rehire them. They have a very lofty goal of filling 95% of those positions by December 31st, 2022, which seems quite astonishing.
Yeah.
I don't know if that's possible. So any of you that get your green card, please go apply at USCIS and knock some sense into them about how this process is ridiculous. Maybe that would be a good thing. You can help fill those positions and help the people coming up behind you. Beyond that, Labor Department, I think my biggest takeaway there was they've been working on a new version of the PERM form for quite some time. They're kind of at the final stages of it. We know what the draft of the form looked like, and they submitted it to the OMB, Office of Management and Budget, which reviews all these things before they can be finalized, many months ago. No response for them. The Department of Labor said, we have no idea what's going on with this form. So they have no idea when it's going to be approved by OMB. So that was kind of interesting that even they're kind of in the dark on that. Other than that, USCIS did say something to the effect of, please stop suing us and just talk to us. I don't know if I would agree with that statement, because when we do try to talk to them, they are useless. They don't listen. So that's why we have to sue. But they definitely showed their frustration about how much they're getting sued now. But if they would just do their job, we wouldn't have to sue them. So they claim they would rather us submit, case issues through their public engagement or through the Ombudsman. But then, of course, you all know last week the Ombudsman came out and said, we can't help you with real-time updates on your 485. We can't tell you whether your transfer of underlying basis has been accepted or not. We can't help you unless your case is outside normal processing time for your 485. So basically, the Ombudsman is useless when it comes to employment-based 485s, unfortunately. So that's kind of my takeaways from the conference.
Amit has a question about H-4 EADs, EAD holders. Can they continue working in the U.S. if the H-1B visa holder is traveling abroad for vacation? So that is fine, even though the H-4 is based on the H-1B. It doesn't really nullify the H-4 or the EAD whenever the H-1B visa holder kind of steps outside the country briefly. However, if it is a situation where the time abroad for the H-1B visa holder becomes lengthier, or a situation where it's lengthy enough that the H-1B petitioner withdraws the I-129 petition, that would invalidate the H-4 and subsequently the EAD. But if it is relatively brief, just a vacation or a short business trip, then the H-4 and EAD can continue in the U.S.
All right, well, I think we are out of time for today. Thank you so much for joining us, and thank you, Rebecca, for sharing your expertise with us. We'll be back next week. I hope everyone has a safe 4th of July and enjoys the long weekend.